Hello viewers, in this lesson we will learn about the banking frauds and remedies. Objectives: to learn about the banking frauds, to learn about the legal remedies against the banking frauds. Viewers, now we will learn about meaning, the banking frauds. Frauds and forgeries in banks have become a global phenomenon in the later part of last as well as this century. Banking frauds are criminal acts which occur by using illegal means to receive money or assets from a bank through various means. Banking frauds are worse and heinous than bank robberies because the bank robberies are apparent to the eye, whereas the banking frauds are committed very silently and secretly, coupled with deceit by making use of the trust reposed in the perpetrators. It can be committed by backstabbing also. The incidents of frauds and forgeries in banking sector very considerably increased in the recent times. The frauds are committed by the insiders of a bank or by outsiders and by both in connivance with each other. The negligence and dereliction of duty of the bank staff also would enable the perpetrator to commit fraud and forgery. The RBI monthly bulletin, August 2013, contains the details of National Conference on Financial Fraud, and on behalf of the Reserve Bank of India, it was stated as follows. We all know that fraud, and more so, the financial frauds, have been in existence for a very long time. Some may be surprised, but it is interesting to note that Kautilya, in his famous treatise Arthashastra, penned down around 300 BC a very graphic detail of what we in modern times term as fraud. Kautilya describes 40 ways of embezzlement, some of which are: what is realized earlier is entered later on, what is realized later is entered earlier, what ought to be realized is not realized, what is hard to realize is shown as realized, what is collected is shown as not collected, what has not been collected is shown as collected, what is collected in part is entered as collected in full, what collected in full is entered as collected in part. What is collected is of one sort, while what is entered is of another sort. As you would all agree, some of the above actions continue to be the modus operandi adopted in many instances of financial fraud that have hit the headlines in recent times. The aforementioned RBI bulletin further stated that as on 31st March 2013, the number of fraud cases detected by the RBI are as follows. In commercial banks, the fraud cases detected are 1,69,190 involving an amount of rupees 29,910.12 crores. The total fraud cases detected in the banks, NBFCs, and other financial institutions are 1,76,547, amounting to rupees 31,401.01 crores. Thus, the highest number of fraud cases involving high volume of money are detected in commercial banks only. A bank fraud can be defined as a criminal act committed through illegal means to get money or any property owned or held by a bank or obtaining money from the depositors by fraudulent means posing as a banker. Thus, the bank fraud could be committed either against the depositors by a person posing as a banker or against the banker by unscrupulous customers to the bank. Basically, the bank frauds are criminal offences as enunciated under the Indian Penal Code 1860 and the other related legislations, even though under the provisions of the Indian Contract Act 1872, the contract involving fraud or forgery is voidable. Against the bank frauds, both civil and criminal remedies are available to the affected persons. Different types of bank frauds. The banking frauds are multifarious in nature. Depending upon the modus operandi, they are classified into different types. They are narrated hereunder. 1. Accounting frauds. This type of fraud is also called fraudulent bookkeeping. In this type of fraud, the sales and income are overstated and the worth of the company's assets are inflated. When the business organization is making losses, profits are shown, the records are tampered, fraudulent loan applications are made in an attempt to get more money to delay the imminent collapse of the business entity. In this type, the banks are virtually cheated. 2. Check kiting. Check kiting is a type of fraud which is globally termed as the float, which means the money is temporarily counted twice. This type serves an operational purpose in banking as both the paying banker and the collecting banker show the check amount as an asset. However, when intentionally the float is exploited, wherein the paying banker has no sufficient funds, it will lead to a fraud. 3. Stolen checks. In this type, the fraudsters may steal the checks of somebody and then may open bank accounts under assumed names and deposit the checks. 4. Forgery and alteration of checks. In this type, the checks are forged with the signature of the depositors by obtaining the blank checks. Sometimes the checks are also printed and then forged. Alternatively, a clandestine material alteration made on a check validly issued. 5. Uninsured deposit banks. All the bank deposits are not insured. Sometimes a bank calling for public deposits may be uninsured or even not licensed to operate. The depositors are taken for a ride. 6. Frauds relating to demand drafts. In this type, the bank staff may be involved. Here, the connived employee may remove a few DD leaves and issue them like regular DDs. Normally, they are drawn payable at a distant city. The draft is encashed at the paying branch. The fraud could be detected only when there is a proper reconciliation of accounts. 7. Unauthorized trading. In this type, the perpetrator of fraud engages in unauthorized trading to recover the losses and in turn tries to make a gain by utilizing the funds received from the banks. 8. Loans obtained fraudulently. In this type, the borrower obtains a loan and then declares bankruptcy or vanishes with the money. The borrower may even be a non-existent entity and the loan is merely an artifice to conceal a theft of a large sum of money from the bank. 9. Fraudulent loan applications. In this type, the borrowers furnish false information to hide a credit history filled with financial problems and unpaid loans to corporations using accounting fraud to overstate profits in order to make a risky loan appear to be a sound investment from the point of view of the bank. 10. Forged or fraudulent documents. Here, forged documents are often used to obtain loans. A document claiming that a sum of money has been borrowed as a loan, withdrawn by an individual depositor, or transferred or invested, can therefore be valuable to someone who wishes to conceal the relevant details. 11. Net transfer fraud. Net transfer networks, such as the international SWIFT interbank fund transfer system, are tempting as targets as a transfer, once made, is difficult or impossible to reverse. As these networks are used by banks to settle accounts with each other, rapid or overnight transfer of large amounts of money are common. While banks have put checks and balances in place, there is a risk that insiders may attempt to use fraudulent or forged documents which claim to request a bank depositor's money be wired to another bank, often an offshore account in some distant foreign country. There is a very high risk of fraud when dealing with unknown or uninsured institutions. The risk is greatest when dealing with offshore or internet banks, but not by any means limited to these institutions. There is an annual list of unlicensed banks on the US Treasury Department website, which currently is 15 pages in length. 12. Fraud in bill discounting. In this type, a fraudster uses a company at his disposal to gain confidence with a bank by appearing as a genuine, profitable customer. To give the illusion of being a desired customer, the company regularly and repeatedly uses the bank to get payment from one or more of its customers. These payments are always made as the customers in question are part of the fraud, actively paying any and all bills raised by the bank. After time, after the bank is happy with the company requests that the bank settles its balance with the company before billing the customer. Again, business continues as normal for the fraudulent company, its fraudulent customers, and the unwitting bank. Only when the outstanding balance between the bank and the company is sufficiently large, the company takes the payment from the bank and the company and its customers disappear, leaving no one to pay the bills issued by the bank. 13. Frauds on debit cards and credit cards. Debit card and credit card frauds are very widespread as a means of stealing from banks, merchants, and clients. 14. Money laundering. Money laundering is an age-old practice of fraud. Money laundering means any scheme by which the true origin of funds is hidden or concealed. Money laundering is the process by which large amounts of illegally obtained money is given the face of having originated from a legitimate source. 15. Other areas. The other areas of banking frauds involve the counterfeiting of checks, bank drafts, travelers' checks, and like ones. Viewers, we will now learn about the legal remedies against the banking frauds. The remedies available against the banking frauds are both civil and criminal in nature. They are discussed hereunder. Civil remedies. 1. Indian Contract Act 1872. Any bank loan, facility, benefit obtained by means of coercion, undue influence, fraud, misrepresentation is voidable. Sections 15 to 19A of the Indian Contract Act deal with this subject. If the parties are under a mistake as to the matter of fact or law, the agreement is void under sections 20 and 21 of the Indian Contract Act. Further, if the consideration and objects are unlawful or immoral or opposed to public policy, the agreement is void under section 23 of the Indian Contract Act. Even if the considerations and objects are unlawful in part, the agreements are void under section 24 of the Indian Contract Act. Section 17 of the Indian Contract Act is more relevant in the subject of banking frauds, which reads as follows. Fraud defined. Fraud means and includes any of the following acts committed by a party to a contract, or with his connivance, or by his agent, with intent to deceive another party thereto, or his agent, or to induce him to enter into the contract. 1. The suggestion as a fact of that which is not true by one who does not believe it to be true. 2. The active concealment of a fact by one having knowledge or belief of the fact. 3. A promise made without any intention of performing it. 4. Any other act fitted to deceive. 5. Any such act or omission as the law specially declares to be fraudulent. Explanation. Mere silence as to facts likely to affect the willingness of a person to enter into a contract is not fraud, unless the circumstances of the case are such that regard being had to them, it is the duty of the person keeping silence to speak, or unless his silence is in itself equivalent to speech. Thus, the above ingredients are mostly prevalent in bank fraud cases. The remedy is a common law remedy through a civil action by way of filing a civil suit seeking return of money, compensation by way of damages by the affected party. Derry versus Peake, a decision of the House of Lords, UK, is a landmark judgment on fraud. The House of Lords observed that fraud means a false statement made knowingly or without belief in its truth, or recklessly careless, whether it be true or false. The fraudulent misrepresentation is a false statement which is made by a person who does not believe it to be true. The Supreme Court in Sri Krishna versus the Kurukshetra University observed that in order to constitute fraud, the person making the statement must have been aware of the falsity of the statement, and the party defrauded remains ignorant of the correct situation. Fraud is committed where one person induces another to enter into some contract or transaction on a false belief by a representation of fact which is not true and which he does not believe it to be true. But if the other party has the facts before it or has the means to know, he cannot be said to have been defrauded, even if a false statement has been made. Even if the motive of the person indulging in deceit is laudable, he cannot escape from the consequences of his action. Thus, in the light of the above decisions of the apex courts, based on the evidence on fraud, an appropriate relief is granted by the courts to the victims. Further, under sections 142 and 143 of the Indian Contract Act, in case of any guarantee obtained by misrepresentation or by concealment, the guarantee is invalid. Here, guarantee includes the bank guarantees. 2. Torts. Under the law of torts, a judge-made law by the doctrine of stare decisis, the bank is vicariously liable to the affected customers for the frauds committed by its staff. The banker, as an employer, is vicariously liable for the misdeeds of his employees. The Supreme Court emphasized this point in State Bank of India versus Syama Devi and in Bank of Bihar versus Mahabir Lal. Criminal remedies. The criminal remedies are in the form of charging the perpetrators of banking fraud under various criminal laws, especially under the Indian Penal Code. The result is not by way of damages made available to the victims, but by way of punishing the offenders. Hence, in criminal action, the affected persons cannot claim any damages, unlike under the civil remedies. However, under sections 357, 357A and 357B of the Criminal Procedure Code 1973, the victims may claim compensation from the fines which may be imposed and recovered by the criminal courts from the convicts, but the concept and mechanism of civil courts is totally different and it is more effective. The different criminal laws under which action lies against the offenders in banking frauds are narrated hereunder. 1. Indian Penal Code 1860. The banking frauds are covered under different provisions of the Indian Penal Code, as the term fraud is not defined under the Indian Penal Code. Relating to the banking frauds, the following provisions of IPC are applicable. A. Sections 107 to 120 relating to abatement. B. Sections 120A and 120B pertaining to criminal conspiracy. C. Sections 161 to 171 relating to the offences by or relating to public servants. D. Sections 172 to 190 relating to contempt of the lawful authority of public servants. E. Sections 191 to 229A relating to false evidence and offences against public justice. F. Sections 405 to 409 relating to criminal breach of trust. G. Sections 415 to 420 pertaining to cheating. H. Sections 421 to 424 relating to the offenses of fraudulent deeds and dispositions of property. I. Sections 463 to 477A relating to the offenses of forgery, making false documents, and property marks. J. Sections 478 to 489E relating to property and other marks, including counterfeiting currency notes or banknotes. K. Sections 503, 506 and 507 relating to criminal intimidation. 2. RBI Master Circular on Frauds, Classification and Reporting. The RBI has issued a Master Circular on Frauds, Classification and Reporting dated July 1st, 2015 and issued instructions and guidelines to deal with banking frauds by the banks, police authorities, and the Central Bureau of Investigation. Further, vigilance wings are established in all banks. 3. Prevention of Corruption Act 1988. Against the perpetrators of banking frauds, various provisions of the Prevention of Corruption Act are also applicable. 4. Prevention of Money Laundering Act 2002. Against the offenders involved in the banking frauds, the provisions of the Prevention of Money Laundering Act 2002 also apply. Well, viewers, I hope you have enjoyed this lesson. We'll meet again. Thank you.